boy went down there one day, it shot up to like 30, but not many. The biggest crowd they had was within the last week. I know for a fact that there is a crew in town filming some stuff with some people. And I know for a fact that Karen is very aware of this, even though she was not somebody who was directly spoken to. And I can tell you more off. But anyway, the only time that there was a large crowd was that time, right?
And so just to stop real quickly. So I just timed it. So Margaret is glitching for me, and it's about every 17 seconds.
Yeah. That's interesting because nobody else is glitching. Should I come back on? Am I glitching for you, Kate?
You're not doing anything wrong. So you just glitch again. Apparently it's like a YouTube thing.
You're glitching.
Yeah, it's happening on other channels too. Yeah.
Okay. Yeah, because you just glitched for me.
Yeah.
It's not me. It's you.
Anyway, I'm in the Matrix.
I've been sucked into the Matrix. That it's probably StreamYard.
But the people in chat are saying they're seeing it on other streams on YouTube.
Right.
But so who are using probably StreamYard, also
they might be. Who are probably also using StreamYard, is particularly in this sphere. It seems to be the most used streaming software. I don't think that I've seen anyone streaming that isn't using StreamYard in this particular case.
Right.
So I'm checking right now.
So what do you think? Let's talk about, I spent a long time last night and early this morning. I was texting Kevin, at 6:00 or something?
Yeah. You woke me up.
Woke him up. Sorry. You should have had your phone off. But I was thinking about the fact that Hank Brennan didn't call rebuttal witnesses. Let's talk about that. What do you guys think? I'm sure that's what they want to hear. Margaret, thank you, Karen. That was nice. Okay. I get distracted by the comments. But anyway, what do you guys think? Let's Kevin, what do you think? And maybe I missed your talk here, but
yeah, the only thing I can really say about it is what I was talking about is I'm not in the courtroom. And I gave a story how last year I was coming back from the Court TV shoot in Dedham, and I was in an Uber, and I was on the phone talking to somebody about how it went, talking about the case. And you're not thinking about the Uber guy really listening. And when I hung up, he goes, "Oh, is that the Karen Reed case?" Well, it turned out my Uber driver is an assistant prosecutor in one of the other counties or one of the other courts near Boston. And I won't say which one. And he was a real character. So we talked the rest of the way home about certain things. He professionally knew Lally. He said, he wasn't a fan of Lally's courtroom style, but he said Lally he'd be the last guy to ever lie anything unethical. He knew Lally personally in that way. He said, Lally's a straight shooter. But what he said, when it comes in any court case, I'm going to be a little crude here because I'm going to use his language. So I'm sorry, I got ladies here, but I'm just going to be honest about his language. What he said was, it comes down to the lawyer, and the lawyer with the biggest dick wins in any court case. That's what he said. But what he meant by that was, it's the lawyer that creates a connection with the jury, and whatever lawyer makes that most powerful connection, they're feeding out of your hand, and you're going to win. So you're a lawyer, Margaret. So you can tell me. Obviously, you're not going to agree with the biggest dick part of it, but you kind of get the way what he meant by it.
Well, it's funny the way you said that. I'm not offended at all, but it's really funny the way he said it. Like, I think of, excuse my language now, but I think of the swinging dick, and I think of, I hate to say it, but I think that would be Jackson, like meaning, the big swing. But I like the idea that he came up with as far as the connection. It's so important. Now, I was very busy at 6 a.m. texting all these people, plus someone extremely close to the case, as you know who it is, Kevin. Yeah. And as far as the prosecution, I know that they very strongly that they have a very good connection with jurors. Mm-hmm. And I
want to bring in Court TV crime and justice correspondent.
Sorry about that. Volume. I'm pulling up Court TV. I want to see if the glitch happens here too, but I'm going to do it without volume. But please continue.
Oh, and so, again, it's all about connection. But it's really interesting because I also spoke this morning with two people on opposite ends, And the one person said, well, I can tell you who they are. John DePietro really was there in court, and he feels the jury is, eating out of Hank's hands. Like they love Hank. They're into every word. They're writing down everything he says. Now, when I spoke with Sue O'Connell the other night, of course, from Canton Confidential NBC, she will say the extreme opposite. And she's been in court every day. So, it's hard for me to tell. I think there's some confirmation bias. So I did go to another connection with the prosecution, and they feel very strongly. But I wish I could have been in the courtroom. It's killing me because I like to see for myself.
Right.
Yeah.
So I heard from somebody who knows a court officer in there.
Yeah.
Who doesn't really have any kind of a side in this, doesn't care who wins or loses, doesn't really even follow the legal aspect of it. But he said that he's seen the jury reacting positively to Karen, to Hank in a way that he doesn't normally see in the courtroom, and he's safe for various trials. So, so that could be a positive indication for Hank on that side.
Yeah,
but tell.
So going back to the idea of not calling rebuttal witnesses. My understanding from prosecution people, is that they recognize the fact that the jury is done. Like they've heard enough, and they're ready to and deliberate. So if Hank had gone forward and presented his up to 3 rebuttal witnesses, at least Welcher, the dog DNA person, that the jury may have resented him for it. And I also spoke with a judge about this as well this morning. I called everyone this morning. People are probably mad at me. Like literally, I was texting people at 6, 7 o'clock. So that's what I'm from my inside sources.
So we'll see.
I had said that I thought it made sense, right? At this point, after 31 days of trial, and all that back and forth, what is one more expert going to change for these people, right? They're done. They're so done. The judge has noticed. She's made comments, right? So like we know they just want this case. And it's like, you're not just, if he tried to limit his rebuttal to just Welcher, because I think that's really the only issue that was outstanding in controversy. The dog bites are very
DNA. No dog DNA would have been
but
nice.
that came in. He can use it in his closing because he crossed Russell on it, and Russell acknowledged. So do you really need the DNA analyst at that point when you can just put, it's not a very strong argument on its dog bites, right? There's no real context that they can put it in that makes very much sense and reconciles with anything that they've seen over the last 31 days, right? So like, why breathe more oxygen into that? I think Welcher would have been the only viable rebuttal witness towards the end, in my opinion.
Let me ask you, Kate. Just ask you this, Kate, because I may have missed this. So they never brought in anybody during the trial to introduce the idea that there was no canine DNA. They only introduced it through Dr. Russell.
Correct.
Yeah.
I mean, that's a blunder.
I kind of agree with Kevin there.
If you were saving that for the rebuttal, and then you didn't do the rebuttal, then you shouldn't have saved it. You should have introduced it earlier, like Adam Lally did, and I can only call that a blunder. That should have been introduced.
I guess I don't really see how the dog bites reconcile with all the evidence, or that it really narratively makes very much sense. What are they trying to say with this dog bites? What bearing does that have? I've always looked at it as the dog bites were one of several desperate attempts to place John O'Keefe away from the flagpole and into the house, right? And so even the rest of their argument, where they're now moving towards he had to have fallen backwards in the garage, which is pretty weak too, right? And I think, again, like if you're inclined to go down that direction, then you're not dealing with what you've just seen only in court for the last 31 days with an open and unbiased mind. Like, let's just be real, right? I think that the more that you breathe life into the dog bite thing, the more complicated it becomes. And it's like, especially with the sweatshirt blunder, what do you want to open hearten it up to all that cross about the fucking holes and make a bigger deal about that?
Well, then it should have been brought in earlier. It should have been brought in under the main case, the case in chief, just like Adam Lally did. if there was any chance you weren't going to use that for rebuttal, you should have made sure because it was not a long testimony. You could have done that on earlier in the case and brought in. I don't know. It's just so you've got this major piece of evidence. So the defense now has put in at least 2 witnesses that are opining that this was caused by an animal, those injuries, and the state has really powerful evidence against that they agreed to, they sent to testing and they didn't use it. They said evidence. I don't really know how to call that anything else.
One of those experts that testified to it acknowledged that there was no dog DNA, number one. And number two, I think that experts are experts and they're going to be instructed, right, Margaret? They're going to be instructed that experts don't say absolutes, that they're just offering opinions.
Right.
That, so you really have 2 shaky experts that say that they could be, but can't really tell you how they can be. And what significance does the dog have, really? I mean, I don't know.
They'll be talking. Here's the problem. It was brought up, so jurors will be debating about whether those scratches came from, something other than a collision. And then they'll be taught. I mean, they're not going to discount it. By the way, I thought I'd read for you. I'm not going to say who this is, but this is from a judge who spent, he's many years as an attorney, a trial attorney, and he's a very judge is pretty high up. So I can't say his name, but I will say that when I said, I asked him this morning, I'm like, well, what do you think about Hank Brennan not calling any rebuttal witness? He's been following the case. He said, this is a quote from the judge, totally the right decision. Hank made some good scores with Rentschler, ultimately ended fairly strong. Expert would have been attacked on x-rays, no fractures, and the fact he didn't even try to do an accident reconstruction. Additionally, from all indications, this jury is done. They don't want to hear anything else. I think they resented Hank Brennan for calling another expert. So that's from a very qualified judge who's seen a lot of trials. Interesting.
Well,
I watched.
Oh,
no,
sorry.
Go ahead. No, you go.
I guess my final point on the whole rebuttal dog DNA thing is when you look at what happened with the dog DNA when it was introduced to the public. Really, was it that clincher that we were hoping for? No, it introduced a bunch of ridiculous conversation about the pig DNA and dog treats. I just think that the jury was done. Everything at this point, they're done. They just want the case. There's nothing that anyone can say. You bring on Rentschler or not Rentschler. See, I do the same thing.
It's the same. I know.
Yeah. So you bring in Welcher, you might score. And really, what could he testify to at this point? He's not going to go do that whole reconstruction. He already explained why. And I think that if you're looking at it logically, it makes sense, right? We can't route. And I mean, by contrast to me anyway, Rentschler's argument sounds ludicrous. And that's before you add all, you got to remember the last jury per Bowtie Ronnie, and take him with a grain of salt, but he's claiming that the jury largely disregarded them because they thought that ARCA was hired by an insurance company. That was the inference that they drew. So they largely disregarded them. This time, you don't have to draw any inferences about who hired them even, because they're confronted with a tremendous amount of very damaging bias-related, testimony with these guys. And so I think that through that lens, what they're saying sounds even more ridiculous, because it's circular logic to say, if we can't directly recreate this collision, it didn't happen. We don't have to look at anything else. That is an insane argument to make. And that's what he was doing, really. He wasn't just giving an opinion. He was making an argument for Karen.
Yeah.
So I think what the prosecution needed to do here, and I think maybe they did, but I'd like to hear you guys talk about it, was create a pattern with all of the defense experts where it came across as though kind of they weren't playing objectively with what they weren't just giving their objective opinion on the case, that they were weighing in for their side. And I think you definitely had, so even just for example, the hostility of La Pasada or whatever her name was, the way she jumped on Hank just even when he said good afternoon. Was there a pattern there with all of those experts that came out that showed that they, or even like DeSorga, didn't run any of his own testing?
No, he didn't.
He just was brought in for the purpose to Burgess, and that's it. I found that. So did he effectively establish a pattern so that by the time we got to Rentschler, the expectation was, all right, this is going to be just another defense expert that has been a gunfighter, so in a way that's come in to try to, to help the defendant. Did he establish that kind of pattern that went into that? Because their qualifications that were there for all of these witnesses, these experts. The question was their credibility, and did they have kind of a problem with the jury? Do you guys think?
And well, in hindsight, I would not have called DeSorga because they didn't really get very far with him. He didn't do his own testing, and he's just really saying, correct me if I'm wrong, that he believed he used the wrong timestamps. He used the iPhone timestamp instead of the Lexus timestamp, saying that there was a few extra minutes after that backup event. So maybe, in other words, maybe he jumped out, maybe O'Keefe jumped out of the way and his phone locked and something else happened to him. I think that confused the jury. He should not have been called. But so I would have I think in hindsight, I would have Rentschler is definitely their strongest witness, in my opinion. After that, I don't think the Plow guy did much for them. Barrows got killed on cross-examination, right?
Yeah. I think also Dr. Wolf was strangely that those videos really helped the prosecution.
Yeah. The videos, that's what I was going to say. Yeah, the videos helped the prosecution. Technically, I don't know. I guess, yeah, I think Rentschler was the strongest, and I can't say, maybe the dog bite expert as to raising doubt as far as in the jury's mind, like, oh, well, maybe, I don't know, there will be a debate over that, those injuries to his arm, in my opinion. Right. So what do you guys think about now that we have hindsight? What do you think about some of those witnesses and whether they were worth calling?
I think that, again, I think that the defense is good at probably prompting a conversation that is very quickly overcome when you zoom out, look at all the evidence, and apply some common sense, which I'm sure is going to be what Hank Brennan is strongly imploring the jury to do in his closing, right? As well as all the, I'm sure that he's probably going to highlight all the things that Jackson promised in his opening that never came to be.
Well, there's a problem. So it's really interesting. That was part of my secret text messages flying back this morning at 6:00. And may not do that because hold on. Keep talking.
I think what you're saying is he may not bring promises in a specific way because it reminds the jury of the defense argument that John went inside the house. Is that what I'm trying to?
Or is it possibly shifting the burden? If Hank mentions that, is it shifting the burden to him?
Right.
So, and that may not be appropriate, so.
Right.
I think it's a very strong, I've gone over that, but the jurors took notes, and maybe usually what happens, they listen to closing arguments. Then the judge gives them long-winded instructions on the law. Then they go into deliberations. I've been a juror myself. And it's not good to take a vote. Hopefully they won't do that in the beginning. So usually you go piece by piece. So they may start with the opening statements from the attorneys, or they may just start with the first witness.
Right.
It'll be interesting because opening statements are not evidence. They are what the attorneys anticipate will come out in the trial, what their story should be. They are important. So,
I think that I think that the credibility of the defense, regardless, and I can see the burden shifting that would be problematic. So I will take that out of my expectations. I think what you're still left with the defense case, though, I can only think of one. I'm trying really to think. I feel like Dr. La Posada remained with her credibility pretty much untouched across. I know that there were some questions about her past as the medical examiner, and that has come out in a lot of cases that she's been in. Of course, every attorney is gonna bring that up. But other than that, which I don't think will have a huge impact.
No, she handled that well. She did very well when questioned about that.
So, but I would say that she's probably the only witness that remained relatively unscathed credibility wise. Barrows, although not really, he wasn't personally, he didn't walk away looking shady necessarily. But
no, but he got he got destroyed on cross.
Yeah, not in the, I guess, yeah. So for his testimony, I think was neutralized on cross. I guess my point is, and I'm struggling to articulate it this morning. Most of the witnesses, I think there was potentially a cumulative effect in the way that their credibility was exposed, right? So you have Dever pretty much right out the gate accusing them of threatening her with perjury. Then you have Lucky Lawfren, who is confronted with these threats that he received. And I think that if we're honest, even though it wasn't explicitly discussed, and yes, he denied it, there is no way that the jury is going to miss his demeanor through that and be able to read between the lines, right?
Yeah.
Right. Especially because he did make some concessions about I was, the harassment's better since I testified. And then you have Arca, which I think probably I agree that Rentschler was the strongest in terms of how conclusive his opinions were, and they're all qualified and educated, but the credibility, I mean, they're deleting text messages and talking on Signal and having, lunches and disparaging the prosecution and talking about testimony.
Was that made clear to the jury? I know it was brought up, but was it really done in an effective way that the jury's going to have that on their minds? And I missed some parts of this, so you can tell me. Yeah.
He was confronted with it. And again, even though this, it's enough that I'm able to know what happened with knowing he never showed this video that he indicated that he had, but we all know what's on it, right? Because of the questions being asked, which aren't necessary, that's not the evidence, but his demeanor and his answers. He was so evasive to the point to where he was claiming, I don't even remember what I had for lunch yesterday, but he distinctly remembered that he had a ham sandwich with the Reed team. He doesn't remember any of his conversations. He doesn't remember. He never outright denied having a conversation stating that he would take an Uber to look more partial. His only retort to that was, well, I didn't take an Uber. Why would I do that? Right? He never outright said, I didn't say that. Just I didn't take the Uber. He was so evasive, saying that I only had text messages about directions, but I deleted them. And this is on the heels of Signal and deleting 100 text messages with Dr. Wolf and not complying with court orders and violating sequestration orders. I think when you frame it like that,
it's on directions
again,
right. I mean, you just Google where the courthouse is.
Right.
See, for me, the problem with ARCA, and I did miss to this, so you guys can tell me if this was brought out, but the way you had to attack ARCA is that you have this, they're hired by an independent entity. We're not allowed to say what it was during the trial, right? And they're only given a narrow range of evidence from which to conclusions. They come up with conclusions, and now are they married to those conclusions? They're not, and then they're joined up into a relationship with Karen's defense team, which becomes at some point improper with this communication and this secret communication. You have to expose that. And so once is this confirmation bias that once you've made these conclusions, you're married to them, and you're going to keep now everything that comes through, you're going to have that confirmation bias. And I wanted to see them go harder after things like the text stream data on their website. And I had found this last year and put it on the channel. They bill themselves as experts on text stream data. And so what Dr. Rentschler would say is, well, it didn't matter because we had already determined that John was not struck by a vehicle. But the testing they did only considered weirdly narrow range of possibilities, such as throwing the cocktail glass at the taillight, and then later The
weird.
demonstrations that they did involved the taillight striking John's forearm, which absolutely would have shattered his arm. But nobody says that they didn't know what the stage theory was. They only considered a very narrow range of possibilities themselves. And it started to feel like confirmation bias, like they're designing their test to fail. And you know, I just think that unless I missed some of that stuff could have been drawn out better on cross-exam. But I admit I did miss some of it. So you guys could tell me if I did, if that stuff was all more effectively done than I remember.
I mean, yeah, I thought Brennan did a decent job on cross. He went over as much as he could with pointing out the flaws in Rentschler's theories. And, you know, I thought the strengths really were that much Rentschler discounted. What about the pieces of taillight found at the scene? You know, what about, like, I'll you know, and I like how he ended it. You don't know how this tail light broke. No further questions. That was strong. I mean, I took, for me to go through the whole thing, it's kind of tough early in the morning. It was a lot of
I know it's
scientific.
tough.
And so I sound like, but yeah, I think that he made
when you like, I just be like, are you so confident in your conclusion, Dr. Rentschler, that even when you got the vehicle data, you just didn't care about it? You ignored it. You weren't going to look at it because you had already made up your mind. So have you already made up your mind because you're so sure of your conclusion, or are you just really, that's the side you're on now? You know,
and that's what I mean. And also, and he did push on that. You know, he did all the evidence that was excluded, and you don't know. But that's also, you know, in the backdrop there is, we've established that he has a very selective memory when it comes to his relationship with the defense. And I was saying this, I don't know if you heard before, Kevin, but I mean, the last jury discounted ARCA just based on the inference that they were hired by an insurance company. That's not even in the same realm of the glaring credibility issues that were drug. I mean, he got Wolf to admit that did you attempt to portray yourself as completely neutral last year? Yes, we did. Okay, you know, like that's all but admitting, you know, the signal, the deleted messages.
I mean, that helps. And the attitude. I think the attitude on the stand from Rentschler was just, you know, he was very combative from the start, just like La Posada was. So, you know, I feel like they're doing whatever they can to help the defense, and they don't like Brennan. And that came across to me. They can't stand Hank Brennan. So, and the jury saw that.
And if the jury does like, you know, Hank Brennan, then, you know, that's what I feel like, you know, you never know what a jury is going to do. You just don't. But this is, you know, the most evidence I think you'll ever see in a hit and run. And I think that there's this like thing, especially on social media, where everybody views every single day, every single witness sort of in a vacuum, and we discuss each witness at length. And that's not how you deliberate a case, right? You have to look at everything. And so, you know, even I haven't done it in a while, but sometimes I'll go on TikTok and like try to talk to Free Care and Read people. And, you know, I think with just a little bit of prodding, which I'm assuming will happen in the deliberation room, a lot of these arguments part, you know, the investigation was horrible. Okay, what was horrible about it? Red Solo cups. Okay, so let's go ahead and toss out the blood evidence that was collected in the Red Solo cups.
Who cares about the Red Solo cups? Exactly.
What does that change, though?
Nothing, because it's John O'Keefe's blood, and you know, so what? It's John O'Keefe's blood. We're not disputing that.
Yeah, but I mean, just assume that it wasn't then, okay? Assume that it wasn't. Pretend that the blood doesn't exist. We discount it altogether. We take it. How does that affect everything else? And it doesn't matter. It really doesn't. You don't get very far with that to reasonable doubt. I mean, even the arm injuries, okay? So we don't know how the abrasions happened. What is that? Well,
that's important. I think how the abrasion... Yeah, the arm injuries are important because did they occur from a collision with the SUV, or did something else happen to them? I think that's a crucial point that the jury is going to be deliberating on. It's like the crux of the case.
I have to admit, I was disappointed that we didn't have a more specific explanation. The accident reconstructionist Aperture hired by the state. Now, you know, they were honest and said we can't do it. We don't have enough information. But I still was disappointed that we didn't get that. All right, this, if you look, because we've had people in just on our side, just, among in our chat and stuff, do their own work where they look at photos of the internal components. Once you remove the housing that was removed on the corner of the taillight, you have these little plastic prongs and things like that. And they've looked at that and said, this created this particular damage here. And they've tried, but that's, I would have thought that at a professional level, that could have been done. And even before Aperture, or even before the first trial, when I talked to multiple cops, they all said they could, that the regular police explain this, but that accident reconstructionists, when they get down to it, will be able to explain pretty much every piece of injury here. And so maybe they were wrong on that and naive, and that didn't happen. But it didn't happen here. So.
And I think it's not.
Well, that might be, but but how does that affect it when one side has a very specific explanation from multiple experts, and the other side just says, "Well, we don't know." Does "we don't know" translate into reasonable doubt?
How did he die? What, like, if you go back to, like, and this is usually how I sort things out too, but everybody agrees on the cause of death mostly, right, which is this catastrophic head injury. Now they disagree about the level of hypothermia, but he was found at 80. But it's the catastrophic head injury, and everybody agrees that it takes a tremendous amount of force. Okay, so I mean, the arm injuries, I think it's enough to cause some conversation. But if we just say we don't know about the arm injuries, set that down, you're still left with this catastrophic head injury, with this woman claiming that she hit him at some point in time or another, and specifically speculating that she may have clipped him, who was established drunk, with her taillight pieces all around the body and in his clothing. I mean, I don't think in any case you can necessarily identify how every single scratch, scrape, I mean, if somebody dies from asphyxiation, but they also have lacerations on their legs, does that change anything really? Do we
You have a point there.
We're talking about the jury expectation. We're talking about the jury expectation. We're not talking about trying to convince me or Margaret.
I could be on a jury,
and you may not have to
be on that jury,
and you may not have to literally
that
have
jury,
to
man. You'd be talking the whole time, Kate.
You may not have to literally explain every single injury, such as the scratch on the nose or something like that. But if you have something that's in dispute, that one side is presenting multiple experts to say that these injuries, you have to at least establish in some plausible way how those injuries on the arm could have been taken place. You got some pretty odd, horizontal parallel tracks in 6 different locations on the arm. You have to at least explain a plausible way that either the taillight housing, it's not enough to just say, well, pieces of glass coming off could have caused that. I think that's a very specific pattern of wounds there. And I think, so I'm just saying, I personally expected a better explanation. And if the jury expected that too, then you could have a problem here. I'm just being realistic about it.
Yeah, I do think that there's going to be a lot of discussion how those arm injuries happen, because they have to look at they're taking the totality of all the evidence, and that was discussed multiple times by both the prosecution and the defense. We've seen so many the jury in so many photographs of that arm that have been put into evidence. So they're going to look at it and they're going to analyze. I mean, remember Randy with the bow tie, the last juror. He said it all boiled down to what happened to John O'Keefe. Like basically, was there a collision or not? That's what it's going to boil down to. And I think that will, if jurors can look at those scrapes on the arm along with the head injury and say, okay, it's makes sense that taillight shards could have caused those. We don't know exactly, how it makes sense. And along with the head injury that he hit the hard ground and he died as a result, then, you've got guilties, maybe on manslaughter, possibly on second degree murder with the act. But I do think that they're going to look at the totality of all the evidence. And it's going to boil down to what happened. What happened to John O'Keefe?
I personally, I feel like I feel like everything on everything about this case screams yes. So I can only speak for myself and assume that there's probably others that think like me, that having a specific explanation for the arm wounds. I don't think that the dog bite is a real good sell. I mean, I across the board, most people that I talk to, despite credentials, like do not consider Dr. Russell to be a particularly credible witness. Oh, sorry.
Yeah, I hear you there. I didn't think she was that credible either, but the difference is we have been living with this case for 2 years, where the jury has only been living with it allegedly for the last 32 days or longer.
Right.
So
Right. See,
I try to look at it with an open mind as to what is a juror going to be thinking and analyzing and talking about with other jurors.
When I did my own kind of mock opening statements a couple months ago, so what I focused on, it's like we're almost getting ready to go in, but focus on the timeline, which shows that nothing else could have happened and there was no time to plant evidence. Focus on the physical evidence and focus on the data, and just really, if you zoom in on those things, there's no other possibilities here. And if you can make a jury's, the more you distract them with other things, the more they have other things to talk about. And that's what the defense wants to do.
Of course.
And that's to the advantage. And that's to the advantage of the defense.
Mm-hmm.
But if you really zoom in, then let's make sure.
Here we go.
Yeah.
The charge is very important. So a lot of people don't like to listen to the charge, but
for the record, before the court is Comal versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Ms. McLaughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Robert for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little? Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of close of all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russ testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning, On January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog which was absent from the home, Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. Again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed a month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Albert who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins. Who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required finding not guilty on all 3 indictments.
All right, thank you.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There's evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth case in any way, shape, or form. A couple of specific examples when it came to Officer Barros. His testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the light was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the same shots from that Ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and request that the defendant's motion be denied.
So, Mr. Yannetti, you know I view this in the light most favorable.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay? All right, so regarding the charge, so we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor, and I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today. I think it's.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right, you filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Alessi's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're going to go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does a request for, and I understand the court's position might be on this, but as far as the instruction related to murder charge, the Commonwealth is only seeking an instruction on third prong.
All right, so we will deal with that. I'm going to go through the defendant's instructions, or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction to propose on page 4, reaching a verdict. Just, I will make it crystal clear, though I think it was, and I was upheld on it, so I will make it crystal clear, okay? So I'll give you that, Ms. Giannetti. This what is evidence? I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, I'm going to take a look at what I gave last year. I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
Object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction from third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from the defense, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that were put into evidence, or anything of the like. So in the instruction and the arguments are based or predicated on evidence, not, and obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions of counsel are not evidence. So what the Commonwealth would submit is if the court looks at what is actually the evidence in this case, there is no basis whatsoever for not only a Bowden or third-party instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material to package evidence. Custody was contaminated and corrupted. There was evidence of the bias, the investigator failure to pursue other suspects, specifically telling his friends that the home was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't
Allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian did.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that, not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay?
That's crystal clear, Judge.
Okay.
And that's really what I was seeking, just clarification based on
Yeah. So Mr. Iannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
Just while we're on page 8, I just wanted to, Alma does have an objection to the DG instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Mr. Iannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously it's not the strongest DG Batista argument that we would have did not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to do.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounding her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr. Haley?
And I would also add, Your Honor,
Sure.
they did seize her vehicle at around the same time. So, that it goes to the issue of custody and my client being able to not answer.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the troopers spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, over the course of that day. They spoke to her while she was seated on the couch in her parents' living room. The parents were present. No one was restricted from being. And it did not end in any sort of custodial situation. She was taken into custody. She was arrested. Yes, they did seize her cell phone and her vehicle based on information that they had developed over the course of the day and from statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in a parent's living room into a custodial interrogation. The bigger issue that I have placement, as far as there's already been within the same request for jury instructions or request for humane practice, and then following the DAG and Batista language in the defendant's request for jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of humane practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and having his testimony from the stand, that initially she said she was fine with answering questions, but they wanted any details. And then when the questions became centered on, or more centered on these laws. At that point, and I know that's not evident to the jury, but of course, well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview, and I don't think that rises to the level of a case instruction. So I would ask basically that everything on page 8 prior to the relevant instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at your residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's going to happen, it should happen once, not
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn, so is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We'd ask the court to repeat that one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there that I would object to.
Okay.
That's when a police officer or someone else works for a law enforcement agency.
Oh, what do you mean by that?
I think that was taken into account in the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that language comes.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
If I might just, as far as the photographs,
What page you on?
16.
Okay.
One suggestion there was indicates, now the Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs.
Fine with that.
Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? Sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any guilty that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right, so did I give it any other time that there's another event that I should highlight? I don't think so.
I don't think there was an instruction of that one.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
We would object to the prior bad acts being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt.
You're on a call.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
No, so the only,
1 second, let me just pull that up. Okay?
Your Honor, Collins' request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice, and essentially what Commonwealth is requesting is that the jury be instructed
Speak up.
merely on third prong malice, as that's the only one that really applies to these factors. So
Okay.
the Commonwealth here, the first two prongs are essentially extraneous in this situation, and you don't need to see explanation of the jury. Avoid confusion.
Do you have supportive case law for me to single this out? What do you say, Mr. Yannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, not intent to kill him. It was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at the position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have it.
I'm inclined to go with the model. I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason for this. But I understand, and I don't certainly want to take.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the panel.
If I alter it, it means I remove those two. That's all.
Right, no, we just want to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want an OUI instruction? You were.
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit. Right, is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's rulings.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it.
Oh,
But I'm going to
okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so.
The only other issue, Your Honor, is we do have a.
Hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it, and I'd prefer not to have to. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count 2, Your Honor. If I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth. Can I hand
Okay.
the proposed copy to the board?
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. All right.
So you'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually in
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obvious of lesser included and the number of elements that are different for each lesser included. And we were uncomfortable for not guilty at the top of the form, and then multiple options for multiple different types of guilty. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go into the next lesser included offense, and again, same analysis, go to the next, until they finally reach the final verdict, which the lessest, or the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least looks like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser includers, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth would submit is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if Your Honor is aware, there was a case recently, while this case was going on, tried before Judge Olau, in which he had similar issues. And I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser. But I could certainly doctor, but it's somewhat helpful, of course.
Better. I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering, okay.
Do you need an extra copy?
Sure.
This is the
Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Thank you. Mr. Lally.
Just one request, circling back to the constitutional field instructions. So Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in his arguments to the jury related to specific areas which we would need conditional approval before we did. So the two areas that are sort of this is within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal that came to her parents' residence in Dayton, and then certain statements made in reference from the various clips of the play of her statements.
Okay.
In particular, would be the one where essentially she says that it defecated to her.
Okay.
Whatever the exact location.
All right. Ms. Giannetti, do you want to weigh in on that?
Yes, really, objective to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. And in fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other statements.
Yes, so I did want to ask you, though, Ms. Giannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No,
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Giannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redactions.
that's great. Thank you. One less thing you all have to do today, okay? I know. All right, so let's make that, are we switching that new redacted version with the exhibit number? Do we know what it was before? Excuse me. The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
This is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just. 209, is everybody in agreement that it's exhibit 209?
Yes.
Okay.
Does the court have a copy or do they need a Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy.
So that will now be 209 in evidence. You know what, can we make that 209A? We need, Ms. Giannetti, we need to keep record of the first one that was not redacted, so any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah. Yeah, so we'll switch it back to ID, and this will just be 209. All right, did we have an ID number on it originally? Can it still be that?
Is it redacted, the NNN? Or is it, no, it can stay that.
Okay.
Right? Is this the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
So that
Our thinking is it needs to be sent back to letters for ID. I think.
Yeah.
So it'll be marked MM for ID.
That's great.
Perfect. And then the redacted version will now just.
209.
Yes.
Yep.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Lessie, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
So, Your Honor, Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Alessio.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, that the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting too, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury, I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue, and I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally. Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen, mistakes can be recognized, acknowledged, and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many, many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi, okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So things take a little while generally. That will assure us that closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, not at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll counsel here at 8:30. All right, thank you.
All rise to the court, please.
Is there already one of these? Like, are we swapping?
Yes.
Goodbye.
Okay, so we could, in theory, have a decision by tomorrow. By tomorrow evening. That's probably a little optimistic or unlikely, but we could, in theory, have that. They're going to have all afternoon to deliberate. And welcome, Boomer, if you can hear me. I think Boomer's trying to jump in. With Margaret, we got the chair.
I'm coming.
She's coming now.
Yeah, I'm coming. Just turning my washing machine off. I'm here.
All right, so we have been unable to solve the glitch issue. I don't know to what degree it's a StreamYard issue. StreamYard is the service we use to stream, and most of us use this. I don't know if it's on their end, if it's on my end. I don't know what's going on, but
It's not your end, Kevin.
Yeah.
I'm logged in, and I definitely don't have any bandwidth issues. I don't no CPU issues, and it's glitching. It's just glitching. So, and you had said previously other channels are experiencing it, so it is what it is.
yeah, that's people in chat saying I didn't want to go searching for that during. I tried several things. I opened up another laptop. I was trying to fix it. I got another laptop sitting right next to the Wi-Fi router, but nothing seemed to work. I tried to fix it, but all right, guys. So welcome, Boomer. Boomer still doesn't have a mic on, so I'm not.
Oh, I'm back. I'm back.
Oh, he's back.
Yeah, I'm here. Yeah. It's the Alessi effect. You had me held in torpor.
I'm back.
Drove you out of the house.
Yeah, right. Throw me out of my mind. I have a question for Margaret.
Okay.
Canone offered to put in an instruction for consciousness of guilt regarding the
Yeah.
video clips, and they denied or turned that offer down. What did you make of that? Why would the defense not want her to do that?
Why would the defense not want her to give a consciousness? Yeah, because it helps both sides.
Mm-hmm.
I'm still trying to digest that. Yeah, because I think the fact that the video clips of Karen that are in evidence, and it does show a consciousness of guilt.
Right.
But now I thought she
sounded
was
like-
going to give the standard consciousness of guilt.
Yeah, and it sounded to me like
instruction.
Canone was trying to almost like hand them a helping hand, the way she put it
Yeah.
to him. Like it does have favorable language, and
For
Eddie
both
still was
sides,
like,
yeah.
no, thank you. Yeah. So that stuck out to me.
That was interesting. What stuck out to me, if everybody was following the whole spiel on the second-degree murder charge, did you guys understand what they were talking about? I'm sure you guys did, but I don't know if the audience did. I can explain it.
Sure.
Okay. So in Massachusetts, there's a model jury instruction for second-degree murder. Okay. And it has multiple prongs. We're only concerned with the last prong. So I'll just read you the whole thing. The model jury instruction is always read in full. So it says, for second-degree murder requires the Commonwealth to prove that the defendant caused the death of the victim and that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which a reasonable person would know created a strong likelihood of death. It also requires proof that the defendant did not act in self-defense or defense of another. Now, here's the issue. Only the third prong is at issue here. If the defendant committed an act, which was, according to Hank Brennan in his opening statements, being behind the wheel, backing up at a great speed of 24 miles an hour when she knows that John was standing there, is that an act that created a strong likelihood of death. So the jurors are going to have to decide on that. Both sides don't want her to give the first prong, but she was saying, if you guys can find me a case where it's okay to just talk about the last prong, which is relevant here, then I'll do it. But she said it's not likely that there's a case on it, so I'm going to likely have to give the whole second-degree murder instruction.
Okay.
But that might confuse the jury just a little bit, because they may think, oh, well, they'll be in deliberation and they may say, oh, well, geez, I don't think Karen intended to kill John. And they may be stuck on that, because a lot of my friends are stuck on that. And I'm constantly having to say, it's the act. It's not about intent. It's about, did she intend to do the act, which could likely cause John's death in the situation. So that's one thing that I wanted to make clear about. And does everybody understand what a Bowden defense is?
I do loosely, yes. Everybody in chat know what's up with Bowden? I don't know. I'm not sure.
Go ahead. If you want, you can instruct the audience. No one better than you to do it, Margaret. Here.
Yeah, there you go.
Oh, God. Well, I don't know. So basically, it's a legal strategy that the defense has used in this case, blaming that this was a sloppy police investigation. They failed to pursue leads. It came out with Proctor showing bias toward Karen Reed. So that would be, again, the police focusing in on Karen Reed right away and, investigating, building their case around a suspect, Karen Reed, without looking at any other possibilities like Higgins or Brian Albert and everything. So it will definitely apply here, and the judge will explain to the jury what Bowden is really. So that is going to be included, but it's different from the third party culprit. So she didn't think there was enough for a third party culprit.
No,
So
didn't she give them the opportunity at the beginning of trial? Like, if you can
Mhm.
convince me and bring in the evidence that points to a culprit, a third party culprit, then you can explore that. But unless you
Yeah.
do that, I'm putting the stoppers on it. And they never did. They never brought in any evidence of a third party. So I guess
No.
that stuck them with Bowden as their only opportunity.
Yes, yes. So exactly, there just wasn't enough proof of any type of conspiracy that this thing happened
Right.
inside the house. He was beaten. It's just kind of vague. Perhaps there wasn't a collision because there's this other evidence to look at.
Mhm.
Oh, maybe it was a dog bite.
Right.
Stuff like
She
that.
also seemed to. It's almost like the way that she described it. There are actually three categories. One is the Bowden defense, which involves the police doing an inadequate investigation.
Yep.
Second is the third party culprit, but the third was Bowden based on third party culprit.
Right.
And so
I did
that
hear her
wasn't
say that
exactly
too.
clear there, but she did mention that. Can you go into
Mhm.
that a little bit, Margaret, or is that one's kind of tricky, I guess? But
Yeah, that would be. She did make a point to separate out the two, though. I thought when I'd have to maybe listen again, but basically the concept being, what I just explained, that the police failed to investigate this conspiracy over here, with
Right.
and they were allowed to
something that happened
mention
inside the house.
a third party culprit
Mhm.
as part of that. So for instance,
Right.
they're not allowed to argue that Brian Higgins did the crime, but they're allowed to say argue a Bowden defense based on the fact that the police didn't investigate Brian Higgins.
Correct.
Really
Right.
fine splitting of hairs there.
But they have to. The defense has to be very careful, and she
Yeah.
mentioned this. Very
Right.
careful in what they say.
Right.
So
I
it's
also found a little
dangerous
bit of.
territory.
So while you were talking, you did a great job. I also found a little bit of unconsciousness of guilt, which is actions taken after the crime. So
Mhm.
it says, for instance, if the Commonwealth, and this is in quotes, so this is part of instructions that could be given to a jury. If the Commonwealth has proved that the defendant, and then you list in the crime, so for instance, fled the scene of the accident, which is the first charge here, you may consider whether such actions indicate feelings of guilt by the defendant and whether in turn such feelings of guilt may tend to show guilt on this charge. You are not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of the circumstances of this case. And then it continues with some cautions.
Yeah.
So there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. A person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. And that could be the case here, right? That's what Karen would say.
Mhm.
Karen would argue that at the crime scene, wondering what happened, she had the idea in her head that maybe she had struck John. And that's what she was trying to say later on, that when she said, could I have clipped him? This is
Right.
what she was doing in her later media interviews. But the prosecution is going to argue is that when you said that, those were actually you having consciousness of guilt. And so, I guess the jury would have to decide that. Standing
Right.
alone, such evidence is never enough by itself to convict a person of crime. So that
Mhm.
was the last of what I could find. So I don't know if you want to react to that.
Yeah, I mean that's, and I think if anything, that language helps the defense, right?
Hmm.
Because the judge, basically the jury will be listening. There could be innocent reasons why she said what she said
Right.
in those interviews. So that maybe, did I hit him and all that? There could be innocent reasons because she's thinking about. She's not really sure what happened, and I don't know. It's
Right.
and I think it's good because in fairness, there are innocent reasons why people do what they do, even
Sure.
fleeing the scene. I guess can be. Oh, my
Right, it's
mother's in the
not- well, it's not-
hospital. I gotta go.
Oh, wow.
Attend to an emergency. I don't know. No, not my
Yeah.
mother.
Right,
I'm
well,
just
it's
saying.
it's not
Like there's
it's not,
innocent reasons.
it's
No,
not
I hear
proving
you.
that she fled the scene of the accident. All we know
No,
is she
I
went
know.
home or went home.
Mhm.
and jumped
Oh,
out.
yeah.
So yeah,
Right.
it's-
She
it's
went
not-
home
it's
not
not-
knowing, that
Right.
she hit him, or
Right,
not
that's what
knowing what, or well, in her words, oh,
That's what
he
she would
went
say.
into the house, so I went home because
Right.
they didn't invite me into the party after that. He just stayed,
Right.
and so that, yeah. So there's
Right.
an innocent reason right there why she went home, and of course they're going to be talking about that.
I mean,
So
hiring
go ahead,
sorry.
I'm sorry, go ahead, Boomer.
I was just going to say, hiring a media apparatus to harass witnesses, that might be consciousness of guilt, maybe.
That's not in evidence, though.
I know. I'm
That's
just
not
saying
in
that out loud to
evidence.
say it because it's true. That's all.
Yeah.
And would it be consciousness of guilt? I'm not, we can
I
play
think
that out.
so.
Last year it was in evidence with Jennifer McCabe. Remember
Right.
how she was harassed and all that? That didn't come in this year.
No, that's
I
right.
don't think it came in with any other witness, right?
No.
No.
It came in last year with Jen, with Allie, and I think with Proctor.
Yeah.
But yeah.
Yeah. So
Yeah, it's an interesting discussion as to whether or not, creating a mob and helping contribute to the harassment of witnesses actually constitutes consciousness of guilt. I'm not, because you could make the case that you're, you're trying to get off and you're doing it for other reasons, but because you're on trial, So,
Right.
Did anybody happen to watch the interview or any of the interview last night with the dismissed juror?
No.
I did not. Did you?
I watched about 5. Go ahead.
Who interviewed the juror?
Well, naturally, Turtle Boy, because all of these dismissed Karen Reed jurors have been in touch with Turtle Boy at least since the end of the trial. And this dismissed juror, whose name is Maura, and she's decided to come. She's been in touch with Turtle Boy ever since, and she's decided to come forward. This is someone that I got her email, and I emailed her a very respectful message, told her who I am, said I'm doing. I covered this from a case that you would not consider to be the same or in alignment with your thinking, but I'm doing a book on it, and I do have your story from multiple sources, and I want to give you the chance to give it to me on your own. But I said I'm never going to out your name, and I'm not going to. I'm not trying to pressure you here. I just giving you the chance to react, and that's all. And of course, she went right to Turtle Boy, ran right to him the next day, and Turtle Boy is like, Kevin did something that could get him in a bit of trouble. Of course, Turtle Boy's already out there. And he did it again last night. In the 5 minutes I listened, he again outed the foreman of the juror, his whole name. But this juror, as the juror was on, I was communicating with the witnesses who are my sources on this, who were friends with her and who were drinking with her on those nights in question. And they were like, yeah, she's lying. She's lying. And
what is she lying about? What exactly did she say? Like in a nutshell.
All right. So I didn't take notes from the 5 minutes I watched last night, but she's trying to suggest that that when the judge threw her out, it was all based on lies, and that she had not been out drinking. I know at least 2 nights that she was out drinking and was going into public places drunk, loaded, and shouting out so that everybody could hear that she's a juror, and then she's going to acquit Karen. And the first incident that she did this was very early in the trial. The second incident was the one where part of that story reached the judge, and I know the whole story, and it is a sordid tale. And that was right before both sides ended their case. It was late in that. But it's just, I don't know what draws these people out to want to seek attention. They want to go to Turtle Boy. So she was talking about how the other jurors that were either dismissed or the jurors that became alternates, how they were free Karen Reed. That she knew that based on
like it's fixed.
Yes, that it was fixed. That the lottery that is used to choose the alternates was fixed.
That's not true at all. It would not.
Someone killer says, "Do I have proof of this?" How would I have proof of this? These are people that are sources that are telling me this. I can't reveal their names. You either trust me or you don't. I've been doing this for a long time, and the things I tell you, you make a sense of looking at me and listen to how I talk about the case and how I analyze things. And you make the decision for yourself. But there's no way with anonymous sources, you can't prove something like that. They're not going to, there's a reason they want to remain anonymous because they live in that town. But that's just the way it is. Turtle Boy reports on anonymous sources too. Every reporter, Woodward and Bernstein, report on anonymous sources. So you either trust the source, which in this case is me, or you don't. That's up to you. I have a track record here, and I've been honest on this case, and I try not to report things. I don't report things unless I have multiple sources on them and unless they fit the evidence and I can confirm them in other ways. So you either trust me or you don't, and it's your choice. You don't have to listen to me. I'm not making you listen to me. You can go somewhere else, but I have good sources on this, and you can trust me or not.
So the jurors.
Sorry about the rant, guys.
Oh no, that's okay. So
All right,
so
dude.
basically, did the juror say anything about this trial? Like, I mean, has she watched it? Is there basically what I'm trying to get at is there anything significant that this juror said on Turtle Boy's show that will enlighten us?
Well, so like I said, I only listened to about 5 minutes of it because there's only so much I can listen to Turtle Boy. So we'll probably learn more as we go. What she was talking about was the first trial. So amazingly, she still 100% believes that Jen McCabe is part of the conspiracy. She 100% believes in the 227 search for House Long to Die in the Cold.
Well, that's been
This,
debunked.
despite the fact that the defense seems to no longer make this argument either. The defense has, with the one data expert that supports this, is the very discredited Rich Green. And you mean to tell me that, all right, so he's discredited for other reasons, but you mean to tell me if that extraction and that 227 was not an accurate interpretation of that data, you couldn't find, of the thousands of other forensic data experts in this country, you couldn't get one other one that wanted to come forward on this high profile case and get their name out there by reporting that, yes, 227 happened. They couldn't find one expert to do that because they never presented one in this trial. So it's no longer sane or rational to believe in 227. Yet this dismissed juror, who, like I said, a lot of other problems with her, she still believes it.
Yeah, really.
Well,
I mean,
that was going to be is it like she can offer nothing because she went in with an agenda. She got kicked off because of that agenda. And I would bolster Kevin by saying that both from Kevin and independently of Kevin, we have the same story that's being told. Lots of people know about it. Especially now. And this information was credible enough for the judge. Okay. So this isn't just trust me, bro. Kevin said it. Like, this was brought to the judge and it was credible enough that the judge threw her out. So she's already disgruntled. She wants the attention. She's in bed with Turtle Boy. She has absolutely nothing to offer anything. She cannot, she didn't make it onto the jury. She has no idea what deliberations were like. She was unfit for deliberations. And she's clearly unfit to really voice much of an opinion on this case, honestly, because it's ludicrous.
I agree.
And since I've been talking to Kate for the last, whatever, year and a half, whenever I get something from a source, someone reach out to me, then it begins a process of trying to confirm it. And one of the first things I'll do is call Kate, and she'll likewise do the same when she gets something to me. And if we have something that is just from one source that neither one of us can confirm, we don't report it. There is a ton of information that has come to both of us over various times during this. And if neither one of us can confirm it in some other way, neither one of us reports it. And that's just the way we've been. There's a lot of stuff that comes to us.
Yep.
And
Constantly.
And just, we've always been that way. And so you either trust us or you don't,
Yeah. True. I trust you guys.
Thank you.
That's Kevin. That's what a lot of folks do out there, right? And that's how I cite if they're part of a grift, is they'll take any and all information and they don't vet it at all, and they just recklessly put it out there because they know they can form it into salacious content, whether or not it's real, whether or not it could do damage to people. There's so many people that aren't responsible at all. They just don't care. They don't care about truth or the consequences. Yeah.
And in the long run, I'm not going to mention anybody specific, but there were a couple of other sources that are on the same side as us that don't have this policy. They're so eager to report something, they put everything out there. But it comes back over time to bite them, because if anybody that's paying attention, they realize most of the stuff that they report, or a good chunk of the stuff that they report, ends up being not true. And it can take time for someone to realize that, because they have to be following stuff. But one person that was doing this, starting over a year ago, they would report that, and I'd call up Kate and I said, where is this coming from? Do you know? She's like, I don't know where he's getting it, and then it would ultimately just prove to be not true. So if you want to establish your credibility, that's a long-term project. And I think it comes from always trying to be honest with people and being fair and being responsible with information you get. And it's important to do that.
Well, at best, it can damage your credibility, right? In my opinion. At worst, it can negatively affect other people's lives, indirectly or directly. The kind of damage, even if it's, you look at it and you think, oh, this could be harmless. You don't know what kind of weird, tale it could fuel down the line. I mean, even that alone it's being vigilant is the best way. It's the most honest way you can do it.
Yeah, and you know, obviously, also have to watch out for defamation suits.
Sure.
Right. I mean, I very famously made one of the biggest mistakes of this case. And of course, I'm not a trained reporter, and I was trying very hard to do it the right way. And this is when I had been talking a lot to Sean during the summer of 2023 and trying to understand the possibilities of this case and trying to figure out timelines and all this stuff. And, you know, he was more quick to just accept these things, and I was not. And a lot of these different conspiracy theories. And I was like, look, what motive could anybody have for planting evidence? That was one angle I was looking at. And then when the video came out of Karen backing into John's car in the driveway, I said, look, I said, if you can get an image or a video clip from early enough that shows the condition of that taillight, if it's intact or relatively intact, then there's a conspiracy. If it's not intact and it's clearly broken and missing pieces, then there's not. And so as he was trying to tie all this together, he informed me of something that was based on a kernel of truth. He said that that Karen had been instructed by John to film a drug dealer in the neighborhood, and that so she got the video, and that drug dealer was Colin Albert. Now this tied everything together for me in a kind of a neat little ball. Like, all right, so now I got the motive for why they would want to beat John up, because they're trying to say, hey, you know, this is our nephew here, you know, back off and stuff like this. So without mentioning Colin by name, I did put out a report on that. But within days, I started getting more information and realized that was wrong. And I was very sensitive about the damage that can do to a young person's life, you know? And so I put together, I worked on for about a week on a video called The Anatomy of a Smear, to which I was in part behind. And to try to correct that and say, this was not Colin Albert at all. Now it turns out there was a video, and Karen did take it, give it to John, and John gave it to Kevin Albert, who he knew fairly much better. He didn't know Brian, but he knew Chris and Kevin. And Kevin's a detective on the Canton Police. And so this video is actually in evidence because all that stuff, because Kevin Albert went into discovery. Now, of course, Karen chose not to use it. We also know the name. I found out the name of the person who actually was arrested, and he was a 27-year-old man, not a then 17-year-old Colin Albert. So, yes, I participated in something that I got it wrong. And I, you know, did the best I could to make amends for it. And many times on the channel explained this story in order to try to clear that person's name. But when you do damage to someone, it's very hard to undo it. You know, it's very hard to undo it. So I still don't know to this day if there probably still might be people that believe that. I don't know if I've correctly undone the damage that I contributed to by that story. But that was fed to me, and I guess I was vulnerable to it because it kind of put things together in a package for me that maybe understand motive and why someone might want to beat John up and stuff like that. So yeah, I that's the biggest mistake I've made, and I've tried to learn from it, and I will never forget it, you know, and I'll always regret it.
I think Karen was running off of like local rumors at first, you know, like to smear certain people, certain witnesses. And there was a few that turned out not to be true. The whole, wasn't the Nebuchadnezzar story that John had this contentious sort of relation, and it turned out that it was an inside joke, and it was actually quite harmless, and it was not what it was made out to be. It was spun from a rumor. And I think a lot of those rumors, like Karen was putting out very early, you know, to try to gain traction with supporters. Like, look how weird this is, or, you know, there was contention between these people. And I mean, it blew up in her face when it turned out to be, not only was she incorrect, but I mean, there was like a, you know, friendly bond between some of the people she was trying to put shade on. And, you know, that's
right. They even showed in the last trial an image of Chris Albert and his wife outside the home of John, and like playfully giving him the finger or something.
That's right.
But what they didn't say was why Chris Albert and his wife were there. And it's because, now remember, Chris Albert had for years he'd only moved that January, a few weeks before John's death, had owned a home just a few houses down from John Albert. So they were neighbors and friends. And John had asked Chris, when they were going on vacation and going to be away, John asked Chris and his wife to keep an eye on his house.
Yep.
So you want to suggest there's a feud there, but it was actually the friendship was such that they asked these people. That's why they sent the picture. They would playfully send it to him when he was on vacation. So I mean, it's, you know, the distortions that come out of this defense team are just unbelievable. And some of them came out today, in Unetti's argument for, for a judge's ruling to dismiss this case. I mean, the way he distorted things, again, it's just what they've been doing since day one.
Day one. Yep.
Mm-hmm.
Absolutely. Shameless, man. Yeah. Shameless and desperate. That's how I would describe the entire defense from jump.
I was talking about this before when I was on by myself earlier, that David Unetti and Alan Jackson, it should be reminded, both. Now they did, and we heard clips of this in this trial. So the audio interview done with Karen Reed, and all of Karen's lawyers were present for those interviews. And in those interviews, David Unetti and Alan Jackson both told Gretchen Voss that they had never spoken to Turtle Boy. Now it came out later that they both had over a dozen calls at the end of January. At the end of April, when the story was first breaking out, they had over a dozen calls with Aidan Kearney. So they just lied. There's not like any, sometimes Alan Jackson fudges data when he's talking about gaps in the library surveillance video or non-human hairs. There's always like just enough thin sliver of truth there that you can argue he wasn't lying. But when they told that to Gretchen Voss, that's just a lie. So when you're over at Thanksgiving dinner, if you're one of David Unetti's children and you're at Thanksgiving dinner this year, ask him if he's a liar, because your dad is a liar. He lied.
Oh, damn.
There's nothing. Your dad's a liar, dude. I'm sorry.
Ask your dad about how much of a liar he is.
I'm not saying you shouldn't still love him. He's your dad. You have to love him. But your dad did a recording with Gretchen Voss in which he lied.
Yeah.
Just straight up lied. There was nothing short of that.
That's true.
And it came out. That's the thing about lies. Why tell lies if you only tell lies if you don't think they're ever going to come out? But that one did.
They're very flagrant. They do so much of this right in, like I was going to say in public, but in front of cameras in public. Do you recall? It was a while ago now. I believe it was first trial. Unetti walking into court, and the blogger was there, and he gave him like a lower back pat. And I'm being nice. I think it was a little lower than lower back. It was pretty weird. And you're gonna put out the sentiment that you guys don't communicate at all, but you give them weird pats on the way up the stairs. Like, okay, that's common for you, sure. All right. Very strange.
Meanwhile, they're communicating with Arca over Signal app. So, and we know Turtle Boy was communicating with Karen over Signal because initially they were doing some of that stuff through Natalie. And so Natalie was screenshotting those messages because they disappear automatically after 30 minutes. And if she has to send that message to either Turtle Boy or Karen as the in between, she could lose track of what it was if she didn't screenshot it. So she wasn't screenshotting it for nefarious reasons. She was just doing it so she could help them. But was Alan Jackson communicating with Turtle Boy over Signal? I'm going to guess that he was.
I would assume so. Yeah. With all the lies we've heard and then the truth we've seen, it's a healthy assumption, but I'm willing to take that. I'm willing to accept that. Yeah.
Right. So it's just
any update on the Turtle Boy trial and then bench trial?
I don't know. I haven't heard it. I'll probably check in later. I'm not following it super closely, honestly.
Yeah.
I found this to be more interesting. And I think that there's a slim margin, but otherwise that conviction is probably all but foregone because it's quite clearly on camera. I suppose the only thing that could, I don't even know what could save him at this point.
Yeah.
You could hire that guy with the little measurement wheelie doodle and get him to lie. Say it was 110 yards away. He's innocent, Your Honor.
Right.
I think Turtle Boy has a better chance with this particular trial than some of the other.
Oh yeah, for sure.
Comparatively.
Yes, this is not. If he wins this one, it is not at all an indication about how the future trials are going to go. This is a very different one.
Not at all.
Yeah. I agree.
Yeah, this is bad for him. What he's facing down the line, that's horrific for him.
Yeah. So it's just. I'm sure, Margaret, all the jury trials you've been in front of to see what's going on here and how this system works with these alternate jurors who. Well, I mean, this shows the effectiveness of Karen's campaign to pollute the jury pool. And
I just
this is why I confronted this with Nick the other night. But I don't understand. this is what it comes down to: integrity. If you're
Yeah.
any one of these content creators, Turtle Boy, The Glare, or whatever, how do you in your own head, if you think of yourself as a good, honest person, how do you rectify the facts that you've been running around saying Karen's lies, which we now know are lies, about 227 and stair climbing and all this other nonsense for a year and a half, which now the defendant herself won't even tell the jury that, did not present one expert to tell the jury and that stuff.
No.
So she used you. So if you're the Glare sitting there in court with with Karen's parents and her family, they used you. But you benefited too, because you grew your audience.
He's making
made
a
lot of money.
ton of money.
Yeah.
Conspiracy sells.
Yep.
I mean, that's all we have to say. And think about, I wonder how much he makes on his, I don't go and watch his live streams, but I'm sure he makes a lot of money on his people donating to his live streams.
He makes just from his subscribers, which he charges $14.99 a month.
Oh yeah, I forgot about
what?
He's got several thousand subscribers.
14.
So do the math, and that's just
Just from that alone, he's making at
so.
least
What would
$30,000
you're
a month.
at? So I'm a month. So I have no idea because I'm not even monetized yet. I'm new to YouTube.
Me either.
Remember that?
Yeah.
Okay, good.
Yeah,
so
no,
I
hear you.
So my question would be, how much money does he make? Would you estimate, Kevin? You're probably the best one to ask. I don't know.
No, I mean, Kay would know more than me, but just from those subscribers alone, I would say he estimated. Well, see, all right. So when I say, so if you figure out $4.99 by the thousands of customers, and it comes out to 30,000, but YouTube keeps a large percentage of that. You might only keep about 40%. So,
Okay.
So let's say he's keeping 40% of that. But then you got the donations, which I remember. So I only watched the show for like 5 minutes last time. The last time I put it on was maybe 6 or 7 months ago. I put it on for a couple minutes. And in that time, I did see some people donate like $700, $800. I mean, crazy numbers to it. So
that's where he's making most of the money, I would imagine. I don't know. But anyway, the bottom line is he's making great money, and conspiracy theories simply sell. They always have.
They do. They
right.
do.
It's consistently with any of the polls taken, Court TV or whatever, shown that 85% of the public thinks she's innocent. And, you know, so this is why there's so much hanging in the balance of getting a good outcome to this trial. I mean, it's, you know, hate to put all that pressure on Hank, but there's a lot riding on you, buddy. Hopefully, you know.
Yeah, but you know what? Those polls are so misleading in a way. It's sort of like going to a KKK meeting and taking a poll on race relations. I'm not kidding, though. 95% of Court TV's audience voted that they would vote not guilty for Richard Allen and what happened to him. Right. You know, like it's just, it doesn't, you know, it's the same thing with, like, if you look at our polls, then at least 75% of the audience is saying guilty on everything, right? It's just the slant, you know what I mean? And people look at these numbers and think like, oh my God, but like the internet has billions of people on it.
Right. Obviously, if you take a poll on Fox News versus MSNBC, it's going to be reflecting that. But I will say, from having talked to people in the public about this for a long time, that I don't know what the numbers are, but the majority of the public does believe she's innocent. It is what it is. But it's not really surprising because the prosecution can't sell its story in the media. Karen can. She's a murder defendant.
Well, there you go.
So, you know.
There you go.
But
the trade-off is that the defense was able to get a lot out in the media that the prosecution couldn't, but the prosecution got everything out in court, and the defense couldn't get any of it in court. So, I mean, which one affects jury deliberations really more substantially?
Right. Again,
paid bots.
Yeah, you're either playing,
that was funny.
You're either playing to the jury or you're playing to your own crowd outside, and I see that getting conflated.
Margaret, who gives the closing first? That's a good question. I got to answer a legal question here. So the prosecution has the burden of proof, and in this case, the defense will go first in closing arguments, and then the prosecution has the last word. They'll go last. And it's the opposite in openings. So in openings, the prosecution went first, and the defense went second. So, but that was a good legal question. Keep them coming.
I wonder going forward, what types of cases, and at least based on what we've learned on this, and we can also look at Richard Allen and other cases too, are the kinds that have the most potential for a defendant to get social media stirred up. Because there were some interesting elements to this case that came out once, especially once, they had time to go, Karen's team had time to go digging around for a while. But even before that, like I've argued in the book, I believe that the conspiracy theory really began as an urban legend that that just developed organically before Karen was arrested, before she was aware of it. Because you just had certain elements here that kind of feed that. So you have the victim is a Boston cop. So anything involving police automatically arouses people suspicious, and the homeowner's a Boston cop. The victim is found unconscious, or as La Posada would say, dead, on the lawn where he's been dropped off for an after-hours party. And so just some of that is going to start to feed urban legend aspects to it there. And then you add in the fact that to the many people, he looked beat up. Now, we know the reasons for that, but to a civilian that doesn't have medical training, you see the swollen eyes and you say, wow. And so to Jen McCabe, he would have looked beat up. So, she would have been wondering, how did this guy, what happened here? How did this guy get here on the lawn looking beat up? Did he get jumped outside? I'm not saying that she thought that. I have no idea. But there was a lot of elements there that could be useful to just organizing an urban legend. And so I was able to find proof of that by Monday that was already congealing, and people were posting in social media that something had happened there. Right, the raccoon eyes. So not every case is going to have this. You won't be able to, to turn every case into the Karen Reed phenomena. So there were some unusual elements here. The fact that one of the people inside the house was also a federal agent.
Yep.
Brian Higgins. So.
And we have let's face it, we also have an attractive defendant. Whether you guys agree, I mean, she, you know what I mean, versus other cases out there. I mean, it's kind of sad in a way. That's what really,
She's white. Most of the people that are out protesting for her are white. She's an assistant college professor. She has no criminal record. She's not like your certain types of witnesses that we see all the time in court that you'd say, all right, this is not someone that's going to win over a big popular crowd,
Right. And another thing I noticed, but here's another example of that. I did a podcast on the Anna Walsh case. She was a missing woman out of Cohasset, very attractive woman. And at the same time, there were some other women that also went missing in Massachusetts, and they were not as attractive as Anna Walsh. And so the media just, went to Anna Walsh, and they couldn't stop putting her picture up over and over and over again on the big screen. And so that's all we saw. And of course, everybody became obsessed with what happened to Anna and that whole story. But I think, that's plays into it as well.
So just a quick announcement. I've been announcing this the last few days. So I will not be here tomorrow, but Kate will be running things. So you'll still be able to get the closing statements. I may be back in the afternoon but I'm not sure what it sounds like. At that point, it'll be in jury deliberations. But I think Monday, I'm going to confirm this later. We're going to start doing a few days investigating while the deliberations are going on. The unsolved death of Karina Holmer, the Swedish nanny, who in the mid-90s was found her torso, so half of her body was found inside a dumpster in Boston. And so this remains one of Boston's biggest unsolved cases. And we have one particular unique angle to offer on this. I had a witness that reached out to me, not a witness, but somebody who had reached out to me who had some information that could be interesting, an angle that could be relevant, because he had lived in that area at the time, and he was participating in this, what they called kink, I guess, or something like that. There was like a kink party scene. There was one bar in particular that was kind of the center of it called Man Ray's. And then I think it exists now. Again, it would close at some point and exists now in Boston. I think it might be a gay bar now. But back then, it was like a kink bar. So one night be gay, another night be people that are into bondage or whatever. It was a whole, apparently there was a whole scene built around this in Boston. And part of that, there was after hours parties that would go on in these kind of upscale lofts in Boston that were very similar to very much nearby where her body was found, and to where she had access. The couple that she was working for as a nanny, they also had a loft in that area, and they would let her use it on the weekends. So there's a range of suspects related to this. So we're going to start digging into it, and it's cool because we're not going to solve the case. But what we hope is that someone in the public who has more information will reach out to us, and we'll get it to the Boston police. And and that's what we're hoping. But because strangely, I've had over the last year and a half since I've been doing this, I didn't push for this. I never really wanted to be a true crime channel, but a lot of tips have come forward on various cases. Another one is the Sandra Crispo case. We'll do that one maybe a little bit down the road too. But I don't know.
And I'd love to collaborate on. I'd love to collaborate on some of those cases, because I did. So in teaching my law class, I did mention the Swedish nanny case and all that. I'm also going to do that serial rapist case too, out of Boston. So I'm going to cover that.
Which one is that? The one that's on trial in Charlestown, or?
Well, he's not on trial yet, but he's facing trial. It's the lawyer who was practicing law in New York City, and there were 7 unsolved, rapes back in. I have to remember it all, but back in the early 2000s or 2006, 2007, and he's been arrested. And I mean, the serial rapist, that's like 7 women, and he actually held somebody up on gunpoint too, like, and raped her. So it's very, very, so that'll be good.
You want to take on the question on the screen from Darlene? Will her bond be revoked, and will she be taken into custody immediately if found guilty?
We talked about this yesterday, and I'm not sure if she, will she be? It would be great. I mean, most people that would happen. So it's a possibility, unless her attorneys can argue that she can, gets to stay out of jail pending appeal. Maybe they'll ask for a stay on that. But it will be interesting. My son asked me the same thing, and I couldn't really give him an answer. It depends on how well her attorneys argue for her in that case. But most of us would be.
Yeah, right. I know that's what I had always heard, that she would be, and she even kind of indicated that in the documentary that was her expectation.
You're probably right. Yeah,
you're right. Let's send some subscribers over to the couple of relatively new YouTube channels. One, Boomer just set up his channel. Again, Boomer, what's the name of your channel?
It is Boomer Live, and if you look it up with the @ symbol, it's @Boomer Live and the number 7 at the end of it.
You got anything planned to start getting some content up there, getting it going? Hopefully you'll
I am. I'm cutting up a couple videos right now. I've decided that some of the material that I've been juggling, I can do versions of it that I think will suit this channel, and then more of an uncut version that's more for people that like more horrific dark humor and things like that. Maybe Kate will want me to put it up on Masshole. I'm not sure. I'm not assuming. But it might fit. It might fit there.
I still don't know what I want this channel to be.
It's tough. It's tough because I'm very eclectic. I'm into a lot of things, and usually I lead with humor or music. That's kind of, what I'm comfortable with, especially music. It's the wheelhouse. But I don't know. I'm just trying to go with the flow, for lack of a better way to describe it. It's tough. It's tough.
And Margaret, what's the name of your channel again?
It's called I have it right in my little yellow thing. Margaret McLean at It's a Crime Media, all one word. It's a Crime Media, all one word. So it's right under my little C in yellow there.
So everybody, please, if you could, head over to these and just click subscribe. That's a very small favor. It won't cost.
Thanks, Kevin.
Won't cost you anything.
So I actually have just one matter. I had gotten a phone call about this last night, and it completely escaped me this morning, but I did want to do this now. Just to clarify and correct something that I guess was said on stream. I don't even know who said it yesterday, but claiming or inferring that Mr. O'Keefe is not well. So I was asked to just clarify that he is fine. He is not unwell. He's fine. I believe, well, first of all, he still works. So, and I believe that, how do I say this gently? I think that it is a struggle to have to sit through all of this upsetting testimony. And I think that it is a struggle to have to sit in close proximity to Karen. And so some of John's family members have elected not to put themselves through that for an extended period of time during the second trial. And I think that, we need not speculate on any further than that. You know what I mean? Because this is a very difficult situation for them, but he is not unwell.
Good.
Yeah, right. I don't remember anybody saying
I
that.
didn't either. I got a call about it and I was like, yeah, no, I'll clear that up. No big deal. And I certainly don't want to like get into, the specific. Right. It's like, just to be clear though, like, so as I don't want to rumors, it's not that this man thinks that Karen Reed is innocent or is on her side or anything. It's just a very emotionally taxing situation for some of his family and his parents especially. So, they're grieving or attempting to grieve in their own way. And, it's tough. It's tough having to sit through this day in, day out for them, I'm sure, and listen to all this really upsetting stuff over and over and over again and watch Karen flail and try to save herself by any means necessary, particularly because the people that they're attacking, Jen McCabe, Carrie Roberts, all these witnesses are almost like family to a lot of the immediate members of that family, very close relationships. And it's been very, very difficult for everybody. So
even just physically to have to sit on those hard wooden benches for all that time. I look at that and I'm like, oh my God, I could not do it.
I know it. I hear you. I would have brought in a cushion for sure. Do you want me to answer that question from Funny Bunny?
What's
outside the jury?
Yeah.
Does the judge give the foreman instructions? No.
Right.
She chooses a foreperson, but there's no separate instructions. But that's a really good question.
Yeah. So those 12 people get into a room and they have to figure out their own process for how they're going to do this. No, there's no guidelines. You figure out on your own. You're guided by the foreman. But there's no set rules. And I think the 2 times that I've been on it, there's kind of a temperature taking that first goes on, and the last jury I was on was maybe 6 days. But so if something like this, where it's like 6-7 weeks, it's just such an ordeal where now you find, and you're not allowed to talk about the case. And now you get to finally talk about it. So I think it's normally you're going to take the temperature and try to find out just generally how people feel about the case. And then the foreman has to figure out a method of going through, and because you have to arrive at a unanimous verdict. And that's difficult.
And also in the judge's instructions, I meant to say something. She's going to change the instruction around a little bit about the verdict and the verdict slip. So she's going to make it more clear. So there won't be as much confusion as the last trial.
Right.
Yeah. So that's good, really, Yeah. Oh, by the way, the serial rapist case that I'll be covering is called the Matthew Nilo case. So that'll be, you've heard of that, right, Kevin?
I remember seeing, I didn't remember his name, but I remember seeing stories on the news with this guy.
Yeah.
He was a good looking guy that,
Yeah, real good looking. Yeah. There we go again. A good looking defendant, right?
Right.
What's this world coming to?
Yeah. He has he has kind of a good looking girlfriend or fiance or something like that too.
She's standing by him. And, there's a lot of questions. Why do some women stand by their man like that when there's all this DNA evidence that he's a serial rapist? I mean, that does some of the psychological aspects of these trials are fascinating to me.
Richard Allen's wife is still standing by him.
Yeah. But there's a component to that I'd like to get into as a woman and all that. So there's all sorts of good stuff on the horizon for both of us. Yeah. And you too, Boomer.
I hope so. Thanks.
Yeah, I was never big into true crime, but I like a puzzle. So I like the unsolved cases. And I do think, for me too, it's about you want to make your remaining time kind of meaningful. And I know that the families who have lost somebody that has become a cold case, meaning it's been around for a long time, one of the feelings that they have is that the idea that their case has been forgotten. And that may not even be the case. There may be that local police department still has somebody assigned to it and still cares about it. But that feeling that the public has forgotten it. So if you bring it back to it, just the act of bringing it back to public attention means a lot to those families, because I have talked to some people relative to that. I'm not going to mention the cases, but it means a lot to them. And then there is always that chance that some tip comes forward, because that's happened too, that could end up being helpful. So I think it's worth doing for those reasons. And I also want to mix in, as part of that, a component of this searching for missing people, because there are missing people that go missing every day.
I know.
In this country, in this state, and some of them end up being suicides, some of them end up being found, and some of them could be murder victims. There's a wide range of stuff, but I think that's something.
Yeah, there's a lot to it.
Yeah, I think that's
I'd like to explore that as well. And there's some other cases where people are still missing, and especially there's one in New Hampshire I'd like to talk about. I'll talk to you separately on that.
Okay,
that would be good too. So.
And
I don't want to take over this with all the missing. We could go on forever on some of these cases, but it would be great to bring some closure to some of these families.
Right. I did a series a couple years ago on Maura Murray, and that's an interesting case. But also, when you get into these cases, it can be divisive because people have different feelings on them, and it's a sensitive issue, and people can get really upset. And I've dealt with. I kind of stopped doing that case for a reason. So obviously Maura's family, is her sisters. I think her dad is still alive. And, that case has been in the public eye a lot. I think Oprah Winfrey's done shows on it. So, but you have to be, but I'm going to cover anything that I do, honestly. And if you report something that is not what the family wants you to report, it's going to create friction. And,
right.
So that becomes a difficult thing. But if your commitment is to the truth, you're going to pursue the truth no matter what. So,
well, another example of women who were missing for a long time that were, they were escorts, and people didn't care about them for a very long time, is the Rex Heuermann case in Long Island.
Right.
So that's another sad situation where it took a lot. I watched that. There's another, I think there's another show on that, and it's put out maybe by Peacock. It's just coming out. I'd like to watch that too, because that case fascinates me as well. I don't know what everybody else thinks, but I just felt so bad for those victims for so long, and the families that they felt that they were lost in the system, and nobody cared about their loved ones because they were escorts, and that shouldn't make a difference.
Right.
So that was my issue. Is like, that's why I felt badly,
Right. Absolutely. But there's a lot to learn from that case too, because I think it's tougher in the modern environment because there's cameras everywhere and phones and stuff for serial killers to kind of operate in the way that Rex was. But they still exist. It's still out there. There's been questions recently and stories in it. I think John DePetro has done some reporting on this too, as to whether or not there is currently a serial killer on the loose in New England.
I know. I've read about that. So I've been stuck with it. We're also entrenched in the Karen Reed trial. I've read a few articles on that. I don't know. The police are denying it, but that would be interesting to follow up on. The thing is, if you have, so what happens is, you may find, a dead body in New Hampshire, a dead body in Massachusetts, a few here and there in Connecticut, but are they all related?
Right.
It's tough to really match that up. So they would have to have either, some DNA evidence or some other,
some kind of a signature on the crime scene. And we don't know because for reasons of their own, the police don't reveal the evidence of the crime scene.
No.
So
and sometimes only the police know about that signature because they don't want copycats either.
Right. So it's harder for us that are amateur sleuthing in the public to look at stuff like that when we don't know the evidence. I think if we knew the evidence, we could probably come up with some kind of useful analysis, but there's understandable reasons why the police don't reveal that for copycats, but also because one of the things that we've talked about in this case is that there are always, in any kind of a high profile case, a significant degree of false witnesses that come forward and even confess to the murders. Even though they had nothing to do with it. In any high profile, this disturbed people out there,
I know.
And so when they do that, the police are going to ask them, all right, tell us what happened. How did you kill this person? And if it doesn't match the evidence they have, they're like, all right, this person's a nut. Now, this happened
Yeah.
all the way back in the Lizzie Borden case. There were a lot of
Yes.
nuts that came forward and falsely confessed.
Isn't that
But we
crazy?
keep, but we keep that in
burns
mind as
resources, right? It's horrible.
yeah,
Slows
absolutely.
down investigations. It's awful.
This is one of the reasons why when I look at any case, I really am skeptical about any eyewitness testimony, because there's all kinds of reasons that testimony can end up being false. And, just look at in this case. I'm not saying Officer Barrows deliberately lied or misled or anything like that, but he seemed to get swept up a little bit when wanting to help Karen. He went to the Omni and met with her team, and in his own mind convinced himself that what he saw that morning or that afternoon when he went to was different than what was photographed in the Sally port. But then when Hank showed him the pictures side by side from the dash cam, he kind of changed his mind again. Like, yeah, that does look like it. But there's someone who was, at least for the moment, kind of a false witness. What drew him to come forward? The other witness, the one who even got mentioned just today by Yannetti, I can't remember her name, who was drinking at the waterfall, and who makes a point of saying Karen came in and kissed John was it Karen kissed John on the forehead or the other way around? John kissed Karen on the forehead, and it was the sweetest thing I ever saw in my life.
Come on.
I mean,
that was nuts.
you're clearly
so
just
often.
that's a bad witness.
That was definitely she should, she's trying to help Karen. She should.
Yeah. And
she just came off like
said that.
Yeah, she came off like a PR agent. That was really odd. Very odd.
And if the jury figured that out, I don't know if they did or didn't, but if they did, that does more damage to Karen, because that actually does damage to the other witnesses that come forward. Because the jury's going to be getting the sense, all right, we're going to get a string now of some shady witnesses here that are just trying to help the defense for some reason. The second thing that she said was suspicious was she bought into the whole defense theory that it was somehow suspicious that Jen McCabe outside the waterfall put her arm around Karen and said, oh, why don't you come with us?
Yep.
So the whole stupid idea that they were trying to separate Karen from the pack and so they could ambush John at the house, which is absolutely ludicrous. But this woman bought into that and was trying to help the defense push that theory when she testified. This is the problem I have with eyewitness testimony that's not backed by other evidence.
Yeah,
I
hear you.
You hear eyewitnesses the depiction of like an armed robbery. One person will say it was a black guy in a white T-shirt, and another guy was right there will say, it was a white guy in a black T-shirt. It's amazing what different people see, and they were in the same room.
Right?
Recollections can be so all over the place. So I mean,
and obviously a lot of time that's innocent. That's just people.
Yeah,
if you have 10 people witness an accident, they got 10 different memories of it. So,
well,
totally
I learned as a young prosecutor way back when. It just reminded me. I was trying an OUI case in front of a jury of 6. That's what they did back in the day in Essex County. And the first state police trooper got up and said the car was red. My second witness, who was another state police trooper, got up and said the car was blue. And I knew after that, done. And of course, it came back not guilty. I knew. And so that the learning curve there was, you know what? I should have just called only one state police trooper.
Right.
Yeah. Oh, God, I'll never forget that. Well,
yeah, that was a big
beings, man.
And I'm like, are you sure? Yes, it was blue.
Right.
I'm screwed.
And they believe it too. That's the worst part of it. It's not nefarious 9 times out of 10. It's just the fallacy of being a human being. Yeah.
So that defendant luckily got off. Luckily for them. Yeah.
All right, guys. Well, that's good. Thank you very much for being here. This was kind of unplanned today. I wasn't even sure if they were going to cover this in court, and then I said, all right, they are. So I'm going to jump on and quickly send everybody the invite. And so I appreciated having you guys here. You can tell my voice; it's still hard for me to talk for long periods.
Yeah, no problem.
But you guys will be back tomorrow. Kate will be running the show. I will be listening to it while I'm getting therapy, and so I appreciate it. And we'll see you all. I'll send you out the links today, and we'll see you all soon.
Okay, thank you, Kevin, for having us.
Thank you, Kevin.
And Kate.
Thanks, guys. Appreciate it. Bye, Kate.
Thank you. Bye-bye.